Right. Good morning, everybody. Thank you so much for joining us today for our webinar, when the party or what happens when what happens at the party doesn't stay at the party, workplace parties and relationships. For those of you who don't know us, my name is Liz Johnston, and I'm an attorney in Verril's Employment and Labor Group. And I'm presenting today with Hannah Saturley, another attorney in our Employment and Labor Group. We both represent employers in a variety of employment-related matters, including those related to the topics that we'll be discussing today. Before we get started, just some housekeeping items. The webinar will be recorded, and the recording, as well as a PowerPoint, will be sent to participants a few days after the presentation. The program has been approved for one SHRM credit and for attorneys a CLE credit, and we'll be providing certificates and information for those to you via email. And I believe we're submitting directly to CLE for the attorneys in attendance today. During the presentation, microphones will be muted, but if you do have any questions during the presentation, please feel free to use the Q&A box or the chat box to ask us. I'm sure at this point, after a few years of Zoom post-COVID, folks are familiar with that. But if you're not, it's those little buttons at the bottom of your screen there. And we'll try to address questions in real time. If for some reason we can't, we'll make sure we get to anything still remaining at the end of the presentation. So diving into today's content, today we'll be talking about issues related to employer-hosted holiday parties, but the principles will apply to really any employer-hosted event that might be relevant to you as we move forward into the season. So next slide, please. All right, so if you are one of those employers planning a holiday get-together, you're not alone. Based on a survey by Challenger Gray and Christmas, they did a survey of 173 HR and business leaders, and it turned out that 64% of those companies are planning holiday celebrations for employees this year. And that's actually the same figure as it was for 2023. So I think the bottom line is that we're continuing to make distance back to in-person events post-COVID. So after a few years of those kind of scaled back of events, we're clearly ready and are, in fact, getting back into the in-person connections, which is honestly great. I think a well-planned holiday celebration can be a great way to boost employee morale, recognize that hard work of your staff throughout the year, and reinforce elements of your company culture through those types of celebratory events. There's always a but when lawyers get involved, though. So that's what we'll be talking about today, the but. Even when events feel social, if they're hosted by an employer, it's potentially still an extension of the workplace. So generally, in the eyes of the law, those events, even though they're not during the workday or might be separate from work altogether in terms of what's actually occurring, those same employment laws that govern the 9-to-5, like Title VII, other anti-discrimination statutes at the state level, wage and hour rules, workers' comp, those can all still apply to your workplace outings and events. And in addition to the legal aspect, when we have kind of that blurring of professional and personal lines, that's when it can create some places where the law can catch up after the fact that we hopefully will help prevent through our discussion today. Part of that is related to interpersonal relationships in the workplace, which is why we're looping in workplace romance, workplace relationship issues with this presentation. But that's all part of the kind of risks of the lines blurring, so to speak. And I'm sure, this time of year you've come across some articles or, notes or, news about holiday events and holiday work parties. And frankly, it just takes a pretty quick Google search to find some highly entertaining posts about employees recalling funny work events or elements of work parties. But there's oftentimes very highly concerning stories that come up in those articles as well. I was looking for a few in preparation for today to see kind of what's out there in terms of this topic. But a lot of the stories that you come across, include individuals' names, they include companies' names, and some even have, photos to events in question. And so today we'll again talk about some of the things that we can do to help avoid you becoming part of a Reddit post or those holiday gone wrong lists that I'm sure all enjoy reading to a degree this time of year. But our next slide, please. In terms of where we're going today, the first part of our presentation will focus on concerns specifically in the wage and hour arena. We'll talk a little bit about workers' compensation and how that applies to employer-sponsored events as well. And we'll talk about third-party liability. Employers have been found liable for accidents, misconduct, things that happened after the party ends, so to speak, especially where alcohol is provided or encouraged or involved in any way. Kind of unpack where those legal lines are drawn in those instances. And from there, we'll move into discrimination and harassment, which is often one of those core issues where the post-party complaints can arise. We'll talk about disability and accommodation issues, as well as religious discrimination and sensitivities, especially when we're in the holiday season. Keeping that element top of mind is really important to avoid creating an unintentional bias towards certain individuals on a religious basis. And we'll also talk about family status considerations and how to keep that in mind when you're planning your holiday events. And then finally, we'll talk about ever relevant topics of sexual harassment and workplace romances and some of the unique aspects of those issues and those relationships, as well as how power dynamics play into those relationships and what can be done on an organizational level to minimize risk associated with harassment and relationships. So with that, we'll go to the next slide, please. So we will start today with wage and hour pitfalls. So one of the big wage and hour issues related to holiday parties is whether time spent at them must be paid. And this is obviously a primary issue for non-exempt employees who are paid hourly or, if salaried, still eligible for overtime. Because as you know, exempt employees who are paid a salary and whose duties meet those duties requirements, their salary covers all of the hours worked for that week. So assuming that those folks are properly classified, their time for these types of events is generally covered. But for our non-exempt folks, it's a common misconception that, if it's a party, if it's after hours, we don't have to pay it because it's not regular work time, right? But there's actually 4 key factors that we use generally to assess whether unique work sponsored or work tangential events need to be compensated. 1 is whether that event is outside working hours. 2 is whether attendance is voluntary. 3 is whether the event is tied to the employee's job. And 4 is whether productive work is performed. So we'll talk about those kind of in turn. So that first factor, whether attendance is outside of regular working hours, it's pretty clear cut. So if your office hours are, a 9 to 5, and your holiday party is at 7 p.m., that's not during regular working hours. So less likely that it needs to be compensated. But if it's occurring at 3 o'clock and employees are generally at work from 3 to 5, it's a much better argument that it should be paid because it's during those working hours. For folks who have kind of shift-based, first shift or second shift or third shift, a little bit more analysis is required to sort of handle the working hour idea. But again, if it's during normal working hours, it's going to be compensable work time. The voluntariness aspect of this is also something that gets a little bit sticky because even if the event is outside of working hours, if it's mandatory for employees to attend, then you are going to want to pay employees to be there. But mandatory doesn't mean, strictly mandatory in the sense that, come to the holiday party or you're going to be let go. I'm sure that's not going to be the case for anybody's holiday party, but mandatory has a broader definition in terms of compensability than, a black and white kind of situation like that. If there's a strong encouragement to be there or, an implicit feeling of pressure to be there by employees, if the message is, look, we have, our officers coming in from out of state. It's extremely important that everybody show up and we have a strong presence there. So we'd really like to see everybody. Those kind of pushes or circumstances that make folks think, hey, if I don't show up, it's going to be problematic for me or, my advancement here or how my boss looks at me. If that's the case, then it's more likely than not like a mandatory event versus a strictly voluntary circumstance. And if it is mandatory and there's that pressure to be present, we're looking at compensable time. A couple other factors in terms of whether it needs to be paid. Is there any work being done at the event? And again, it's one of those factors where it's easy to say, hey, we're not answering customer service calls right now. We're not working on the line during the party. So it's, no productive work is being performed. But if we're having, a company meeting or discussing company goals or having folks recap projects from the year, or doing other things that are work related, even if it's off site, even if it's off regular business hours, even if it's voluntary, those elements can affect whether this is compensable work time. Should also think about whether there is more true work being done at these events. So is there any actual work being performed that is clearly work, but maybe it's a little bit different from folks' regular jobs? So are people helping set up before the event? Are they helping tear down after? Are we, serving drinks, keeping tables clean, helping serve food? If employees are engaging in those types of roles at the events, it looks more like compensable time, time that should be paid. If you have people there who are sort of operating in their HR capacity, being available for questions or issues that might arise during the party, if they're there acting in that way, it's looking more like compensable time to the extent that they are there as a representative of the company in an official capacity, right? So in terms of planning for events like this, to help kind of avoid blurring the lines of what's compensable, what's not, as a step one, make sure that communications are straightforward about whether the event is mandatory and voluntary or voluntary and plan to compensate appropriately. If you do plan to compensate for the event, you could be clear about that in communications with employees about it. And in terms of any work or the activities of folks that are being done at the event, planning ahead is going to be really key to make sure that people understand what the expectations of them will be at the event, and whether they're going to be compensated for them. And it avoids situations where you need to figure it out at the time and figure out pay later kind of considerations. You also just want to have people identified to help the event run smoothly in terms of any actual work that needs to be done. But I will say, it's important to think about these in advance because wage and hour is one of the areas where we see, increasing DOL involvement, and especially where, when we have things like events where a lot of people come and it's a wage and hour issue, the damages scale so quickly, with the treble damages available for unpaid wages, multiplied by the number of people who go. And Maine has a 6-year look back period for wage and hour violations from a statute of limitations perspective. So this is just one area where it's really important to get it right before the actual event. Our last bullet point there for injuries, another reason why it's really important to kind of figure out, whether this is compensable time, whether this is going to look like work time, because injuries and illnesses arising out of and in the course of employment are generally going to be covered by workers' compensation. And so several of the factors that are relevant in determining whether this is work time that needs to be paid are also going to impact whether this is a work-related injury. So if employees are, again, required to attend, if this is mandatory, or if there's a consequence for not going, it's looking more like work. If it's employer sponsored, which these kinds of events will be, we're more in the workers' compensation realm. If the event is for a work purpose, we talked about what type of work might be done there. Even boosting morale or, just generally furthering the employer's interest, it's looking more like work time. If they are paid, it's going to look more like workers' compensation covered time. So, again, having an understanding of what the liability will be in advance, depending on the nature of the event, is key in kind of managing the risk associated with the event after the fact. And with that, I'll turn it over to Hannah on the next slide.
Great, thanks, Liz. So next, I'm going to talk about the part of the party that employers and companies sometimes forget about. So this is about the people that are outside of your organization. So think the bartenders, the caterers, the venue staff, because even if they're not employed by you, you might still they might still be under your umbrella. So there's kind of, like Liz was saying, a common misconception that if an event is off-site, then the employer's legal exposure disappears. Unfortunately, this isn't the case. If the company sponsors, encourages, or even strongly suggests attendance, like Liz was saying, the event is considered an extension of the workplace. So say you rent out a banquet hall or a brewery for a company holiday party, if an employee is harassed by another employee or even by the bartender, that's still potentially your problem. The Maine Human Rights Act and Title VII both make clear that employer liability extends to off-site work-related events when the company knows or should know about the behavior. So it's not just about what your own employers are doing. Vendors and contractors can also engage in or be the victims of harassment. So if a catering staffer is subjected to inappropriate comments by one of your employees or vice versa, the employer still has a duty to step in there. So the key question that regulators and courts will ask is, did the employer know or should they have known? And did they take reasonable steps to stop it? So then when we add alcohol into the mix, because that's where things start to get pretty messy, which is a theme that we'll sort of see throughout this presentation. Under dram shop laws and negligent entrustment principles, employers can be held liable if a guest leaves the event intoxicated and causes harm. So there was a big case out in California where a company was found liable after an employee left a holiday party, drove home drunk, and injured someone. The court looked at how the employer sort of created the risk there. They were the ones that provided the alcohol. They didn't monitor consumption, and then they allowed the employee to drive home. So even though the crash happened off-site, not even at the party, the employer's decision to let the employee get intoxicated at work at a work event was enough to tie the incident back to the job. So that's sort of a good reminder that just because an event ends at a certain time, that doesn't necessarily mean that your liability is stopping at that end time. Some of this risk can be managed on the front end through things like contracts and vendor selection. So before you sign with a venue or catering service, it's best practice to review the indemnification and insurance language. So with that, you're going to ask if they carry their own liability coverage, whether staff is trained to responsibly serve alcohol, and sort of what their incident reporting procedures look like. Kind of a small nuanced step there, but they can make a difference if you learn later that the caterer didn't actually have insurance. So I would say the takeaway is, even though your company might not own the venue where the party's taking place, even if it's your event, you're still sort of on the hook to keep people safe and to respond if something goes wrong. So planning, picking the right vendor contracts, and some oversight can sort of go a long way in this risk area. Next slide. So as I said in the last slide, a big theme throughout this presentation, which I think we'll talk about sort of over and over, is alcohol. It's hard to sort of, I think for a lot of us, to imagine a holiday party without it. But from a risk perspective, alcohol sort of changes a lot of things. It lowers inhibitions, it blurs consent, it amplifies inappropriate behavior, and can turn sort of a fun evening into an HR call. So we tend to see spikes in harassment claims tied to workplace events where the alcohol is flowing freely. It's not just because employees obviously suddenly forget the law, but it's because their judgment and their boundaries sort of fade faster when alcohol comes into the mix. And it's important to point out that we're not just talking about sexual harassment here. Alcohol can lead to all kinds of problems like offensive jokes, often leads to arguments or even physical fights between coworkers. So sort of important to think about alcohol and how we're managing it. So we're not saying don't serve alcohol or saying that alcohol can't be involved at all, but it's important to sort of think about it beforehand and how you might manage it. So how do we reduce those harassment, misconduct claims? A lot of things is, again, going back to like just making sure that anti-harassment policies are current, they're well communicated with employees, and also that employees know that they apply to all work-related events, not just in the office. Training here obviously is also important. So regular practical training for employees and managers can reinforce what harassment looks like and why it's unacceptable. And again, not just sexual harassment here, but any kind based on protected characteristics. So if you do decide to serve alcohol, there's some things to consider. Often limiting drinks to things like drink tickets or setting certain bar hours can be helpful here. So sort of a 2-drink maximum or a clear end time can be helpful. It's good to hire trained bartenders so that they can sort of spot over service issues, faster and better than a coworker or an employee can if they're serving drinks. You might consider providing transportation options. So think like taxi vouchers or certain designated drivers or even reimbursement for ride shares. And then it's a good idea to designate some sober leadership. Liz sort of touched on this before, but it's good for someone in management to sort of be in charge and to make decisions throughout the night. And so that person obviously should stay sober so that they can make decisions if things start to go sideways. And then another thing to consider is having an alcohol policy in general, which can help set expectations and support any actions if needed later. And then importantly, it's just important to remember that your duty doesn't end when you stop serving alcohol. This goes back to the point that I made last slide about the California case. Essentially, if your company is providing alcohol, you're now part of that chain of responsibility. And some people sort of wonder if you can have employees sign a waiver or something before the party saying they won't sue if something happens. And although creative, unfortunately, employees can't waive their rights to future claims. So if someone experiences harassment or an injury, a pre-party waiver won't shield the employer there. Next slide. Pass back
Right.
to you, Liz.
Thank you. So before we jump into this slide, we had a question about do the same legal risks apply to directors, including external independent directors who are not employees of the organization? And I would say, yes, there are risks associated with anybody who's an agent of or acting on behalf of or affiliated with your organization. And the legal risk in particular is going to vary depending on exactly what the legal issue is and what the person's status is with respect to the organization. But, they certainly, there are legal risks for acts by them of, things that are done to employees or that relate to your employees. Perhaps non-employees might not be able to make the same claims uh, under like the Maine Human Rights Act, which only applies to employees, right? But think about anybody who's an agent of or affiliated with your organization as potentially being a source of liability with respect to their actions in this context. Hannah, any further thoughts on that? Or
No, I think you covered it. Yeah.
yeah. So with that, Hannah alluded to, there's more than just sexual harassment at issue here. So we wanted to talk about a few of the different types of harassment that we see with respect to workplace parties and holiday parties in particular. And as a general principle, I think it's, we've talked about making sure that your policies are up to date, that they, apply to events like a holiday party. But admittedly, I mean, things feel different on a, 7 o'clock on a Friday than at 10 a.m. on a Tuesday. But in terms of, having the policies, making sure to educate your employees about the fact that the same policies apply on the Tuesday as the Friday and at work events and at non-work events is important too. I'd also, add in terms of harassment, discrimination generally, I'm sure many of you know it's not all harassment and discrimination claims are the result of a huge overt bad act, right, by the organization. It's oftentimes those small acts, those little, biases that exhibit themselves through decision making of the company or supervisors, or it could be perceived that way, that, is how we end up with a discrimination or a harassment claim. And so thinking about the message of the company cumulatively and how that might be magnified in an event like this, a bigger event around the holiday season, is why it's just extra important to, be mindful of this in this context this time of year and for these types of events, because these types of events can, really kind of establish what the culture is, what the organizational expectations are. So viewing that through the lens of how your employees might see that and keeping in mind those subtle biases, how those are exhibited is important. So with that, we'll go to the next slide, please. Accessibility and disability are one piece of this to keep in mind. So, I mean, this is as simple as making sure when you're picking a venue, does it have ramps to get to the front door? Does it have elevators that make the space accessible? If you're having folks gather on a stage or, giving out awards at a certain part of the facility, does everybody have access to that as part of the event? It can be a really uncomfortable situation for somebody to not have to, deal with accessibility issues during regular work events and the work week, and then have to go to an event like this and be faced with a circumstance that's uncomfortable for them. And after all, the parties for everybody. And so thinking about this in advance can be really helpful to make sure that one, everybody has a good time from a human perspective, but also limit sort of facts that can help establish disability discrimination. Um, Thinking about this as well, venues are very different and they're not regular workplaces. And you can, looking at situations like where are people going to sit, making sure there's seating to accommodate people who might have other physical limitations other than just access. Dietary and allergy considerations are another big one, whether it's for allergies or medical diets or religious restrictions on diet. You might ask employees to notify HR or the person who's planning in advance to make sure that you can accommodate restrictions. But keep in mind that some people might feel uncomfortable asking for that, maybe because it's due to a condition that they're uncomfortable sharing or some other sensitivity. But having options available for folks with a variety of different needs can be a great way to make people feel included and respected in that sense. On that kind of note, Hannah talked a lot about alcohol and the role of that at work events or at like a work holiday party. And yeah, understandably, it's often a part of these types of events. But one thing to keep in mind is that, some employees, as well as many people in the community, have issues with alcohol and substances. And so being mindful that there are non-alcoholic beverages available to folks, plenty of food available, and also activities and spaces that aren't exclusively designed around alcohol are helpful to help everybody feel included in this environment. Because these aren't things that you as an employer might be aware of directly, but they can be triggering or cause people to feel uncomfortable or excluded from an event if it's has a really deep alcohol focus. Um, so keeping in mind kind of, again, the space, the circumstances, what activities are going to be available, what it would feel like for a person who's struggling with those issues to attend the event, is important in helping get that bigger picture of an inclusive party for everybody. With that, next slide, please. Turn it over to Hannah.
Great, thanks. So let's shift to religion and belief. So this is something that can come up pretty regularly for a holiday party, and there's a few things to keep in mind. Under both Title VII and the Maine Human Rights Act, employers can't discriminate against employees based on their religion, and so this includes things like event planning and participation in social functions. So the first thing to keep in mind is scheduling. It's important to be mindful of major religious holidays when setting your date. So you're not, for example, planning your event during Yom Kippur, Ramadan, or Diwali. Even though attendance might technically be voluntary, if the event is strongly encouraged, employees who can't attend for certain religious reasons could feel excluded or penalized. Going back to sort of dietary and ritual considerations, so offering a few inclusive options like vegetarian, kosher, or halal can go a long way, even if it's not something that that someone keeps. Just having different options can help people feel included. Decor and participation is probably where the most questions come up. So if you call your event a Christmas party and the decor includes a nativity scene, that can feel exclusive to some employees. So that doesn't mean that you have to ban all sort of holiday imagery. Courts have generally recognized things like Santa Claus, snowflakes, wreaths are all secular symbols, but it does mean that you should be careful about sort of overtly religious displays. So keeping decorations and themes neutral for your party, again, helps people feel included, and it helps sort of avoid fueling a potential religious discrimination claim. Sometimes the question comes up regarding whether you should be inclusive of all holidays. So in other words, Do we need to acknowledge all of the holidays? It's a good question, and the answer generally is no, because it's not practical or appropriate even to try to represent every possible religion, especially because you shouldn't be asking your employees what their religion is. So the goal isn't to necessarily celebrate every faith. It's just you're trying not to exclude anyone. So the focus here is on being welcoming and respectful rather than sort of exhaustive. Um, so on that same note, as we start to think about things like holiday cards and gifts, the same principles sort of apply. So it's best to use neutral language like happy holidays or season's greetings, even if you don't face the same discrimination risks from sort of external recipients and clients and things like that. And then finally, some employers might be thinking like, I'm going out of my way to do something nice. I don't have to throw a party, so why can't I sort of do whatever I want? Unfortunately, once you sort of decide to host a work-sponsored event, you're still going to be responsible for complying with employment laws. Again, sort of going back to offsite doesn't necessarily mean you're not going to be liable here, and even optional doesn't necessarily erase your obligations here under Title VII or the MHRA. So bottom line is to just be inclusive, sort of keep it neutral, and focus on creating an environment where employees can feel welcome and respected. Next slide. So next we'll shift to family status and other protected classes. This is another area that doesn't always get the attention it deserves when sort of planning workplace events. So first, we're sort of thinking about caregiving obligations. A lot of employees are balancing a lot of different responsibilities outside of work. So caring for kids, aging parents, or other family members. If your event is scheduled on a weekday evening, which is very common, or announced sort of at the last minute, that can unintentionally exclude caregivers. So they may not be able to attend, or they might feel sort of penalized for missing out if attendance is sort of voluntary but noticed. So again, it's not that you can't have an evening event, because that's often the best time to do it. It's just important to recognize that not everyone has the same flexibility. So maybe even considering offering inclusive options like a daytime thing or a family-friendly alternative can be nice. And then within that, we're thinking about sort of inclusive activities. So some workplaces love to get really creative with sort of team games or contests. But when you're thinking about that, you want to make sure that the plan is accessible and appropriate for everyone. So sort of going back to what Liz was talking about, but avoiding any activities that are sort of overly physical or even centered around alcohol. Another subtle but important issue is who's going to be invited to these events. Some employers invite spouses, partners, or plus ones, while others like to keep it sort of employees only. Either approach is fine, but the key here is consistency. So if you're going to allow guests, make sure that the policy sort of applies equally. So you wouldn't want to say spouses only if you mean to include something like domestic partners as well. So just wording can be important to think about. And remember that, again, inviting guests can sometimes blur the professional boundary lines that we talked about earlier. So something to think about, particularly if alcohol is being served. It's good to be mindful of that. Inviting people's partners can sort of change the social dynamics. Also, employees who don't have a partner might feel excluded. So these are just all sort of things to think about while planning the party and ahead of time. Just be sort of intentional about it and make sure it aligns with the event that you want to be having. Beyond sort of family status, there's also other protected classes. So comments or jokes about age, marital status, gender identity, even if meant sort of in fun, can easily cross the line in this kind of social setting. So again, remember that the harassment laws don't sort of stop because the event is offsite or after hours. And that ties into our sort of key takeaway is just to be sort of inclusive and make sure that employees feel included and are treated equally. Next slide. Okay, so we'll pivot now to sexual harassment, which is probably the most well-known and discussed category of workplace risk when it comes to office parties. And we'll start with something that's been in the headlines recently and that I'm sure a lot of people, or pretty much everyone knows about now, which is the Coldplay incident. If you did miss it, the CEO of a tech company and his chief people officer, so essentially the head of HR, were caught on the stadium's big screen during a Coldplay concert. The two were sort of seen to be cuddled up. They were clearly together, and then as soon as they realized that the camera was on them, they suddenly pulled apart. The video went viral, and as you can imagine, the company ended up in sort of full crisis mode PR cleanup after. So this isn't a work event, but it is a good example of how sort of blurred lines between professional and personal relationships can create a lot of risk for your company. So you have a CEO and the person responsible for enforcing workplace conduct policies sort of caught in what appears to be some kind of inappropriate relationship. Regardless of whether any policies were technically violated here, the optics alone raise huge questions about power imbalance, favoritism, and just credibility in general. So why are we sort of talking about this in the context of workplace parties? Because this is sort of exactly the kind of situation that can start or come to light in an environment like this. Parties are relaxed, people let their guard down, alcohol lowers inhibitions, and then boundaries start to blur. So for example, imagine two employees start a relationship or maybe even just have some sort of moment at the company holiday party. Maybe one of them's a supervisor, maybe the other one reports up sort of through their chain of command. Even if everything seems mutual that night, what happens next week when they're back in the office and someone else learns about it, or if the relationship ends badly a month later, these are the kinds of situations that can lead to harassment claims. And even if no one sort of files a formal report, others might start to question whether one's getting special treatment. So we'll sort of dive into this deeper, but that's what we're working with. Next slide.
All right. So I think as a baseline, as we start thinking about workplace relationships and sexual harassment, just going back to the basics of what kind of sexual harassment, exists. And so, there's quid pro quo harassment and hostile work environment harassment. And if anyone's been to our webinars in the past, you're probably familiar with these principles, but for anybody who's not, quid pro quo is essentially a situation where a supervisor or somebody in authority threatens to affect the terms or conditions of employment for another individual, sort of in relation to a sexual favor or sexual act, or there's punishment for refusal to do so. So kind of tit for tat situation. Unless you do X, Y, Z sexual thing, I won't give you a raise or you'll be fired. And in these kinds of situations, if a manager engages in this type of behavior or a supervisor, or whoever it may be, the company is pretty strictly on the hook for that. It's strict liability standard, even if the company more broadly didn't know about the harassment. Similarly, but a little bit different, a hostile work environment type of harassment is really looking at a series of conduct that creates an adverse environment for an employee. So, there's a few key factors here that make it a hostile work environment. One is that the hostility that's experienced is based on a protected class or membership in a protected class. So in this case, in the case of sexual harassment, it's going to be harassment that's happening because of somebody's sex or gender. And this can go male to female, female to male, female to female, male to male. It does not go one way or, with only one direction. It's just harassment based on sex or gender. It needs to be unwelcome to constitute a hostile work environment. And this can be a really tricky factor when we're thinking in the context of workplace relationships or supervisor supervisee circumstances, because there can be cases when it seems like both sides are in on the joke or the conduct, but they're actually not. And so it's not uncommon for somebody to go along with something and have it seem like it's okay or it's not unwelcome. And then we later find out in the context of a charge that it was unwelcome. The conduct also needs to be severe or pervasive. Just little annoyances throughout the work environment or isolated incidences that aren't really extreme are generally not going to be considered to constitute a hostile work environment or create one. There are some things that are egregious enough that they will, like a sexual assault, for example. One instance might create a hostile work environment thereafter. But really, we're looking at a pattern of conduct that's, impeding somebody's ability to perform their job. And there's possible defenses for employers at the organizational level for a hostile work environment, depending on the level of reasonable care that they exercise to prevent or correct sexually harassing behavior and taking remedial action beyond a complaint. But I think the key takeaway in the context of the relationship issue is that sexual harassment isn't always obvious, and it doesn't always start as conduct that is obviously harassment. If an employee is feeling pressured to participate in a relationship with another employee or a supervisor, then that might be resulting from sexual harassment. Or flipping it the other way around, if employees are in a relationship but things take a turn, it can create a situation where harassment is occurring in the workplace, but it's not being, there's no action being taken because people assume that folks are in a relationship or somebody feels like they have to engage in certain behaviors or permit certain things to happen because they're in that relationship. So the risk can be really escalated by workplace relationships. Next slide, please. And Hannah's going to talk a little bit about some of the specifics that make workplace relationships so unique. But, again, I'll speak a little bit to that now because the issue with workplace relationships is broader than just affecting those involved, right? So, and it is a more common issue, and then therefore has more frequent risks than it might seem. So I was reading on a survey done by Forbes, and that survey found that 60% of adults report having had at some point a workplace romance. More than half of those, 57% of those folks, said it impacted their work performance at their employment. 43% of people with a workplace relationship married somebody that they worked with and the relationship had started with. 40% had been unfaithful to their current partner with a coworker as well. I thought that was a pretty startling statistic. And interestingly, 35% don't report their relationship to the employer. And so I think these are interesting statistics, but they demonstrate kind of the really elevated, again, risks and impact on how these relationships flow through more than just the two people involved, sexual harassment risk aside. But their performance is potentially implicated or it is implicated by self-report. Outside relationships that might bring themselves into the workplace through a plus one work event, right? Potential workplace violence or, relational issues there. And the employer might not know about any of this absent a report from the employee itself. Um, so it's worth, considering as we dive into some of the unique aspects of this, the fact that people report that their coworkers see them differently, treat them differently, say that it's increased workplace gossip. These are all tangible issues that affect the reputation, the morale, the productivity of people involved in relationships, and why you should be interested in this in your workplace, even if you're not aware of any issues at the moment. With that, I'll turn it over to Hannah.
Thanks. Next slide, please. So I think the biggest red flag here is going to be power imbalance. And so when a supervisor is involved with a subordinate, it doesn't really matter how consensual the relationship appears. There's always risk that someone might later say, I felt pressured, or I didn't really have a choice. So even if it started out mutual, if the relationship ends badly or if performance issues sort of arise later, those same facts can form the basis for quid pro quo, sort of like Liz was explaining before. And even when both people are happy, others in the workplace might not be so happy. Coworkers who see the relationship can often sort of feel ostracized or unfairly treated, especially if one person appears to be getting things like special assignments, flexibility, or just more attention in general. And that perception alone, even without an actual policy violation, can sort of create morale issues or lead to third-party harassment complaints. And then there's what happens when the relationship ends, and breakups can be incredibly uncomfortable, especially in the workplace, especially if two employees have to keep working together. And then, of course, sort of technology amplifies all of these problems. Without tone or context, it's easy for a message that sort of seemed playful in the moment to come across as inappropriate later. And unlike sort of a comment in the hallway, these messages are stored, and so they create a permanent record. And so if a relationship turns sour, they can often become exhibits later. And then lastly, public displays of affection. Even when something is sort of small in the workplace, it can make others feel uncomfortable. So when you combine all of this, you can see quickly how sort of a private relationship can become a liability. Next slide.
Right. So just a couple notes on things that you can do in the workplace to address workplace romance relationship issues. We've talked a lot about making sure your harassment and discrimination policies are up to date, and that advice, echoed in this context too. And I'd also add, considering a workplace relationship policy specifically can be a good idea. Really defining whether and what types of relationships are permitted, any reporting requirements for that. I think as a general baseline, considering a prohibition on direct reporting relationships or direct reports with spouses is really important to prevent kind of favoritism and discrimination with relation to people who are in a relationship and have power over people's advancement, compensation, terms and conditions of employment, even when things are going well, but then especially when they're not going well or there's a breakup or something like that. So eliminating direct reporting for those who are in relationships is what I would say is the best practice. Another, thing that's kind of floated in the news and whatnot are like love contracts, basically relationship agreements where employees, sign a document saying we're in a relationship with the company, so the company has a record of that. It can be helpful to acknowledge that a relationship is consensual at that point in time, and acknowledge harassment, discrimination, policies and the like, but Hannah, I believe, mentioned earlier, employees cannot waive rights to things that happen in the future and have not happened yet. So having a contract or an agreement or document that folks sign saying, yes, I'm in a consensual relationship and I understand my, the company's position on harassment and discrimination, that does not prevent them from making a claim later of things that hadn't happened at that point in time. So it's an option, but not, necessary to document a relationship. Um, I put settlements and separation agreements up here because sometimes when issues do arise, we settle claims, and there are separation agreements that waive rights to make claims for things like sexual harassment. But it's important to be mindful that there are limitations on what factual information can be prohibited from disclosure, both under state law as well as federal law. And in many states, including Maine, you have to have separate monetary compensation or consideration set forward for any restriction on issues of discrimination. And there are still going to be limits on disclosing to law enforcement and to state and federal agencies and the like. So it's important to consult with counsel on what can be waived and released in those contexts. And lastly, I would add, considering investigations, if you have a workplace romance or sexual relationship, or harassment issue that has gone south, or if you have a complaint, you have a duty to investigate it, and it's probably in your policy to investigate it. And it's also helpful in terms of defenses to those claims as they arise, and to prevent future issues from occurring. So in the context of an investigation, think about whether you want that to be somebody internal or external, in terms of an investigator or legal counsel. It really depends on sort of what resources you have available internally, the severity of the situation, who's involved in the situation. But keeping in mind that an investigation might be warranted into those issues, in some cases, is important. Then I'll turn it back over to Hannah to recap some of our tips and best practices.
Yeah, so I know we only have a couple minutes. These are all things that we've sort of talked about before, but these are some practical tips for what we're calling a low risk, good time. So a few strategies here. Again, limit the number of drinks, think drink tickets or sort of closing the bar early. Hire professional bartenders rather than letting a colleague pour, and plan transportation, make it easy for employees to get home safely. Next, attendance. Again, make it clear that the event is voluntary and that no one's going to be penalized for skipping it. Third, review and update your policies. Holiday parties tend to expose where a policy might be outdated or incomplete. So it's a great time of year to sort of double check your policies. IT and social media. Again, many of the problems that start at the party don't end there. So maybe someone posts a photo or shares a comment online. It's just important to sort of review these policies. And romance and training. If your workplace doesn't already have a disclosure policy, might be time to consider one. And then again, ongoing training is always key. Next slide. I think this pretty much echoes what we've been saying all along, but to wrap up, we hope you have great, fun holiday parties that are compliant, but they're still work events. So, a little bit of planning, a lot of communication, and sort of clear expectations is going to make it a good time. Yeah.
All right. And thank you so much to everyone for attending. We appreciate it. Hope you have a great rest of your day.
Thanks all.